Mr. Foreman and ladies and gentlemen of the jury, we have a case here with some important aspects to it, which I shall allude to at the proper time. It is not so much, as some of the counsel have pointed out, the accident in itself, or the way it happened, although, of course, I am going to refer to that, because that is the basis of recovery if the plaintiff has any recovery, but certain other details as to the extent of the injuries. Do not forget that I am coming to that, and keep your minds focused on that when the time comes. First, as to the way this accident happened, it was due to a collision between a car belonging to and operated by one defendant and a truck belonging to and operated by the other defendant. That collision took place, there is no doubt about it, and you have here among the exhibits marked on a map a cross to show the point at which the collision between the two vehicles is said to have taken place, and a check mark to show where the car was at a certain time described by that same witness. I shall not go into a description of the accident, except to say that the contention of the defendant railway company is that the truck in some way struck against the side of the car. That appears to be the theory. In other words, this defendant contends that it must have been the fault of the trucking company. The theory of the trucking company is that, as testified to by the driver of the truck, the car ran into the truck. I think that is a sufficient statement of the two theories. The defendant railway company's counsel points to the undisputed evidence as to where the glass was broken in the car as evidence that that must be where they came in contact. And if that is where they came in contact, and for the first time, of course it means that the car could not have run across the truck head on as claimed by the other defendant. Now, plaintiff was a passenger on the car. The defendants owed him a duty, but it was not the duty of an insurer, unless you find that the defendant was caused by the negligence of the railway company. You cannot hold that defendant liable. You cannot hold the other defendant liable unless you first find that the negligence of the driver of the truck contributed to cause the accident. You may find neither liable. You may find both liable, or you may find one liable. Your verdict, if you find for the plaintiff, must carefully show against which you intend your verdict to be, remembering that the burden is on the plaintiff to show you by a fairly superior weight of the evidence you believe every fact upon which he relies, including the cardinal fact of the negligence of either defendant and each of the defendants in this case. He cannot recover against any defendant that he has not shown to be negligent by that burden of proof, by a fairly superior weight of the evidence you believe. Now, assuming, and only assuming, that you have passed by that point of liability, you come to the nature of the injuries. There is no evidence that the plaintiff was negligent and contributed to the happening of the accident, so far as the cutting by the glass on his hand is concerned. I believe one of the defendants contends that he must have been negligent to have taken or fallen where nobody else fell on the car. And there is no evidence that anybody else fell on the car. Of course, if you find he was negligent in any further action or failure to act which might have been responsible for a more serious injury, why then you must take that into consideration, because he cannot recover if his own negligence contributed in any extent to his damage, or for any damage in which his own negligence contributed to the slightest degree. With that exception, my charge as I made it stands on the liability. Now to come to the nature of the injury here in the leg controversy, in the case that has taken so much time and attention by you and by counsel and by myself. The plaintiff contends that he had not merely these superficial bruises and contusions on his hand and, I believe, his face, but also that he had a very serious injury to his head. There is where the fight centers. The plaintiff has some testimony to the effect that he had lumps on his head appearing after the injury, and which the doctors connect with the injury. The defendant has offered evidence to the effect that